Welcome to this edition of Ask the Patent Attorney. I'm the patent attorney, the examiner whisperer, Craige Thompson, and I'd like to tell you today about a question that I often get. I just had a client call and ask me this question this morning. How do international patents work? So there are four things I want to tell you about that you need to understand as a business owner, entrepreneur, inventor, when you're starting to think about, well, should I protect this outside the United States, internationally, in other countries, and with a patent? First principle is that there is no such thing as an international patent. There's no global patent. Patents are country by country. Every country has their own patent system and issues their own patent through their own system. So there is no international patent. There is an international patent application process that you will hear referred to as the PCT, or the Patent Cooperation Treaty. And there's also another treaty that patents can be filed from one country and then filed in another country. The most important basics here, not to get too down in the weeds, there's four things you need to understand. The first has to do with non-disclosure agreements to protect yourself with respect to if you think you might want to ever get a patent in another country outside the United States. The laws in each country are different in their patent system. So the United States is a little bit of an odd duck. It has a grace period of 1 year. That is not the case in many other countries. So in the United States, if you publicly disclose or offer to sell your invention, you have 1 year to file your patent application with the U.S. Patent Office. If you don't, then it's lost forever. Now, then if you do happen to get a patent through, it can later be invalidated because you waited more than that year. So you have a 1 year grace period. In contrast to the 1 year grace period in the U.S. and in a couple other countries like Canada has a similar grace period, I think. Most countries in the world, notably Europe, China, Japan, those type of countries have an absolute novelty. And under the absolute novelty rule, the day that you expose or publicly disclose your inventive idea, whatever public disclosure is, that's a factual issue. But basically, the general rule is that day that you disclose it, if you don't have a patent application filed on that date, you just blew your patent rights in those absolute novelty countries, which is the majority of the world. So that's the general rule. And, country by country, there's going to be specifics that as a U.S. patent attorney, I would have to check with local counsel in each country, but what their specifics are in a particular country. But the general rule also is that non-disclosure agreement will protect you from a disclosure when you make it, say you have a meeting with a manufacturer or a supplier or a vendor or a potential licensee, or you have a meeting and the meeting's under NDA. That NDA, in a lot of countries, my understanding is that will protect you against this absolute novelty rule. So that won't be considered a disclosure. So this essentially creates your own grace period as long as no one else goes and beats you to the patent office in whatever country. You can create your own grace period with NDAs. So that's the number one point I want to talk to you about. The second point is, once you leave the United States, if you thought the United States patent system was expensive, wait till you get a load of what it costs to file internationally. The United States generally is a bargain for the value you get, the quality of the protection, and the cost to actually get a patent. For example, today, I was just talking to a client. We got a patent allowed in 10 months on a advanced system without accelerating or anything. So, the patent system can be quite affordable and effective when you follow the right procedures and the best practices. But anyway, I digress. On the international patent side, once you leave the United States, you need to be prepared for things that are called annuities. A lot of these countries, they charge you every single year hundreds, maybe $1,000 just to keep the application alive, and even before it becomes a patent. And so in the United States, once you get your patent issued, you pay a maintenance fee at 4 years, 8 years, and 12 years from when you get your patent issued. In most countries, you're paying an annuity every single year. And then on top of that, if there's prosecution costs and other expenses, and it can really start to add up, translation costs, etc., country by country. So if your eyes are too big for your stomach, be careful. I've seen that happen, and I often talk clients out of going international because it is, finances are an issue. That's not something, international is something you want to really understand why and what your business plan is, why you need protection in a particular market. The third point I want to make today is the ability to defer the cost. You don't even have to decide right away. When we're just filing a provisional or filing a non-provisional in the United States, it's the first patent application on your idea. You've got 12 months under these treaties, the PCT and the Paris Convention, before you have to make a decision and actually make a filing either to the PCT or direct in another country. Most of the countries that anybody cares about are signatories to these treaties. So for the most part, with a couple of minor exceptions, you have 12 months to get your patent application filed. So you don't have to decide right away when you're worried about getting your provisional or your non-provisional first application filed in the U.S. You got that 12 months before you have to even think about it. So don't sweat it right away. It's not like you have to make this big decision right away whether you have to go international or not. Just defer that decision. The last fourth point that I want to tell you about is the main route that most large companies and small entrepreneurs take when they actually want to go the international path is through the PCT, or the Patent Cooperation Treaty. This is by far the most cost-effective and advantageous process that we're using more and more frequently to get an idea so that it has the ability to be protected outside the United States, and by deferring all these larger costs. There is an upfront cost of several $1,000s to get the application started, but you get a couple of benefits. One is that you get a search report, and sometimes that search report can be done by a European examiner or Korean or a Chinese examiner, and you get some insight into what kind of a buzzsaw or not you're going to be running into if you proceed with a patent application in these foreign countries. You can get an early indication. Sometimes we even have the U.S. examiner look at it, so we get an early indication of what the U.S. examiner is going to do. So there's a number of different strategies in how we pick who's going to examine it, what the costs are, but the big benefit is you get to defer the onslaught of the larger annuities that I mentioned, that larger expense and those bigger decisions of which countries you're going to go into and financially commit to. You can defer that for 30 months from when you initially file your typically it's a provisional or a non-provisional in the United States. So you get 2.5 years or 30 months of time to think about it, time to see if it's worth it. And so you're basically buying an option, if you will, to defer the cost, defer your decision about international for 2.5 years when you go this PCT route. Plus, you get a good search, typically that gives you some good insight as to, is this worth investing in or not? If it comes back and it's totally ripped up. The search is non-binding and it doesn't lead to a patent, but it is a search by a patent office and by a patent examiner in one of the designated countries to the PCT. And so it gives you a lot of intelligence that you can then leverage in your decision making, so make a more fully informed decision. Those are the 4 points. NDA to avoid the absolute novelty rule. It's expensive. You got to make sure your eyes aren't too big for your stomach. You do get this cost deferral. You can defer the cost for 12 months. So you don't have to make this big decision, should I start the international patent process or not? Because you have 12 months from your U.S. filing date if you've followed rule number 1. And then finally, the PCT is a very good mechanism for promoting your international, or starting off your international patent strategy. So hopefully this has answered your questions to give you, as the entrepreneur, inventor, business person, some insights as to what you need to know and need to kind of understand to start to get your head around what's the priority of this international. People are asking me about it. What do I say? What do I do? I need to know something about it. Now you know the brass tacks of what you really need to know about it. You don't need to know all the details of the procedures and the processes. What I just gave you is enough to give you actionable information for business decisions. So hope that serves you well. All right. Have a profitable day.